Good day, class. This is Attorney C. Sun. Welcome again to Criminal Law, Book 1. So, today I'll be discussing Article 6 to 10 of the Revised Penal Code. So, let's start with Article 6. So, Article 6 speaks of consummated, frustrated, and attempted felonies. Always remember that consummated felonies, as well as those which are frustrated and attempted, are punishable by law or by the revised penal code. Now, when is a felony consummated? A felony is consummated when all the elements necessary for its execution and accomplishment are present. Okay? And when is it frustrated? It is frustrated when the offender performs all acts of execution which would produce the felony as a consequence, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. Now, what's the difference between consummated and frustrated? Of course, in consummated stage, okay, all the elements, okay, necessary for its execution and accomplishment are present. Say, for example, in a murder case, okay, once the shooter killed his victim, of course, that is already consummated crime of homicide or murder, as the case may be. Okay? Why? Why consummated? Because all the elements necessary for its execution and accomplishment of the crime of murder are present. Okay? Why? Because the victim is killed. Now, in the frustrated stage, the victim suffered a mortal wound, a fatal wound. However, the victim did not die because of a medical intervention of a doctor. Right? So, in the frustrated stage, the victim did not die, right? But he sustained a fatal wound or a mortal wound. But he did not die because of a medical intervention of a medical professional. Now, when is a felony attempted? It is attempted when the offender commences the commission of a felony directly by overt acts. Overt acts meaning an act that is directly connected with the offense being committed, like the act of stabbing, the act of shooting a person, and does not perform all acts of execution which should produce the felony by reason of what? Some cause or accident other than his own spontaneous desistance. One good example is if the shooter pointed a gun at his intended victim, but because of some cause, the gun, upon pulling the trigger, jammed. Therefore, it did not fire. It did not kill the victim. Therefore, the perpetrator, okay, Mr. A, is liable only for attempted murder. Why? Or attempted homicide, as the case may be. Why? Because although he performed an overt act of pointing a gun and shooting the victim, but he did not perform all acts of execution which should produce the felony. Why? By reason of some cause. Nag-jam ang gun. Okay? Other than his own spontaneous desistance. So that's the difference between consummated, frustrated, and attempted. Okay? So we have here three stages of acts of execution. So attempted, frustrated, and consummated. Please take down notes, okay? Because I will ask this in your pre-test. Okay? So, what are the three acts of execution under the revised penal code? So, attempted, frustrated, consummated. Okay? So, consummated felony defined. Okay? A felony is consummated when all the elements necessary for its execution and accomplishment are present. Example, A wanted to kill B, so he stabbed him. Therefore, after stabbing, oh, the victim died. And is the crime consummated or frustrated? The crime is consummated. Why? By the death, the victim died. Therefore, the crime of murder or homicide is consummated. Okay? Okay, so nota bene. Okay, note well. Number one, in crimes against persons. So crimes against persons pertains to crimes of murder, homicide, parricide, etc. Okay. So in crimes against persons, like homicide, which requires the victim's death to consummate the felony, it is what? Necessary for the frustration of the same that a mortal wound be inflicted. Because then the wound could produce the felony as a consequence. Therefore, okay, if non-fatal wound imong na-inflict sa victim and you have the intention to kill, the crime is only attempted. Why? Because in the frustrated stage, the law requires that the mortal wound, the wound that should be inflicted to the victim must be a fatal or mortal wound. If it's not mortal or fatal wound, okay, therefore the crime is only attempted. Take note. I will repeat. For frustrated offenses or for frustrated felonies, there should be a mortal wound that is to be inflicted against the victim. Okay? Because then, the wound could produce the felony as a consequence. But if it is a non-mortal wound, naigo lang sa shoulder, naigo lang sa tiil, that's only attempted. Okay? Number two, if the victim was hit when the accused fired at him, but the victim was able to run, which fact must have produced in the mind of the accused that he had not actually performed all acts of execution necessary to kill the victim, the crime is what? Is attempted, as the subjective phase has not yet passed. Okay? Number three, where the victim was mortally wounded. So the victim sustained a mortal wound or fatally wounded. With accused to stab him in the abdomen. But who did not die due to what? The timely intervention of a medical practitioner, of a doctor. The homicide is frustrated only. Okay? Because the death was not produced. Wala man namatay. Because of a what? Medical intervention. Because of the doctor. Okay? The death was not produced due to a cause independent of the will of the perpetrator. But if the wound inflicted to the victim is a non-fatal wound only, what is the crime committed? Only in the attempted. Okay? Attempted lang. But if mortal wound, frustrated. So number four, if the victim dies as a direct consequence of the wound inflicted, the crime is consummated, frustrated, or attempted. It is consummated. Why? The victim died. Okay? Very easy. Even though there may be no intent to kill, always remember, intent to kill is presumed by the death of the victim. Therefore, consummated stage ang acts of execution. And number five, if the intent to kill is not evident, okay, as when the accused after wounding the victim withdrew, okay, the crime committed is what? Only serious physical injuries. Why? Because in attempted and frustrated stage, there should be what? Intent to kill. But if intent to kill is not evident, okay, as when the accused after wounding the victim, o iyarang giigo og lead pipe, then ni-withdraw na yun siya. The crime is only serious physical injuries because there is no intention to kill and not attempted homicide. Okay, please take note. Okay, frustrated felony. Okay, when is a felony frustrated? It is frustrated when the offender performs all acts of the execution which would produce the felony as a consequence, but which nevertheless do not produce it, by reason of causes independent of the will of the perpetrator. So, example, A wanted to kill B, so he shot him in the abdomen. Okay? So, of course, if you will be shot in the abdomen, that's a fatal wound. Huh? Okay? Your liver might be damaged. The wound is what? Fatal or mortal. So B is expected to die as the wound is mortal. Okay? However, B did not die because he was immediately brought to the hospital and the timely medical intervention by the doctor saved his life. Therefore, the stage of execution is only frustrated. Okay, it's in the frustrated stage. So explanation here, all the acts of execution that would result to the intended criminal design, that of B or the killing of B, were all performed. But the victim or Mr. B did not die. Why? The survival of B was due to a reason or causes independent of the will of the perpetrator of A. Because what? There is a timely medical intervention of a doctor. Okay? So the crime was frustrated murder. So frustrated murder ang crime. Why? Because the victim sustained a mortal wound or a fatal wound, but the victim did not die because of the timely medical intervention, okay, by the doctors. Okay. So attempted, very easy. So there is an attempt when the offender commences the commission of a felony directly by overt acts and does not perform all acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. So example, A would like to kill B. So he drew his pistol. He aimed at B. The bullet, however, hit a passing one in not B. It was seen by the police and therefore the perpetrator, Mr. A, was apprehended. So here, okay, in the case at bar, the offender has already what? Begun an overt act. The overt act of pointing gun and shooting a person. Okay, that's an overt act. That is an act that is directly connected with the offense being committed. Okay? However, the perpetrator was not able to perform all acts of execution by reason that the van passed exactly when he aimed and shot B. Okay? So there was a cause, okay, that happened. Ganong wala niya na igan si B. But naigo man gud sa van. Okay? So attempted. So note as to attempted stage, if all the acts of execution are not performed due to an accident or any cause, the crime is only attempted. Take note of that. Only attempted. But if the offender voluntarily desisted, no attempted felony is consummated. All the acts so far performed may constitute another felony. Kani example A prepared a picklock. Of course, ang picklock that is to be used to rob a house. Okay? And on the way, he desisted. Una-una siya na si picklock. Una-una siya nga, akong kawatan ng balayan eh. But on the way, ay di na ko dayon na lang. Therefore, pag ingon niya ato, dili siya pwede makasuhan og attempted robbery. Why? Because he desisted. Wala man siya gi-perform nga. However, okay, if he is arrested by the police, okay, after desistance, he is liable for illegal possession of picklock because illegal possession of picklock is punishable under Book 2, the revised penal code. Although dili siya makasuhan og attempted felony og attempted robbery, kay wala man siya attempt ni desist man siya, but ang picklock is a crime. Possessing a picklock is a crime. Okay? Therefore, he is still liable not for attempted robbery but for homicide. But for illegal possession of picklock. Okay? I hope we are all clear with this. So directly by overt acts. What do you mean by directly by overt acts? Of course, means that overt acts performed by the offender must be directly connected to the intended felony. If mo patay ka, ano may overt act of killing, the act of stabbing, the act of pointing a gun and shooting a person. Easy. So the attempted felony that is punished by law is one which is directly connected to the overt act performed by the offender, although he has admitted the crime. Okay? So, kani, example, X won the lottery. X put the lottery money in a safe in his house. Y wanted to steal the lottery money in X's house. On that night, Y went to the house of X. In order to enter the house, Y removed the jalousies of the window of X's house. When Y was about to enter the house of X, a barangay tanod saw Y. Thereafter, Y was apprehended by the barangay tanod before he could enter X's house. Y was charged with attempted robbery. Now, should X be convicted with the crime of attempted robbery? The answer is no. Why? Because the act of Y in removing the jealousy window of X is not directly connected to the act of robbery. Because the act of removing the jealousies of the window will not necessarily ripen to the crime of robbery. Because once inside, because if the perpetrator is inside the house, the perpetrator may what? May rape, may kill, or may rob. Sulay, klaro. Indeterminate pa ang crime. Okay, so di gud ka maka-assume nga robbery gud iyang buhaton nito. What if na di siya pat yun? What if mang-rape di siya dito? Okay? Therefore, sa man, he should not be convicted with the crime of attempted robbery. Now, usa may liability ni X if that's the case. So he is only liable for attempted trespass to dwelling. Okay, attempted trespass to dwelling. Always remember that removing the jealousy of the window is the overt act of trespass to dwelling. Muna siya overt act of trespass to dwelling. Kaya masulib yung gasbalay. So overt act na siya. Pag usa may attempted trespass to dwelling. So imong abriyon ang gate, imong abriyon ang jealousy para ka makasulod. O trespass to dwelling ra na siya. Ibasakpan ka. Not attempted murder. Okay? Ayaw mag-assume. Why? Because once inside, the perpetrator might kill, might rob, or might rape someone. Okay? So ayaw mag-overthink. Okay? So if ever madakpan mo nga kuha mo kuha, jealousy window, attempted ra. Trespass to dwelling. Okay? Buyag, simba ko, palayo. Ayaw magbuhat ani. Okay? So it will necessarily ripen into the crime of trespass to dwelling. However, because the barangay tanod apprehended Y before he could enter the house of X, he did not perform all acts of execution by reason of some cause or accident other than his own spontaneous desistance. So, in the case of People versus Lamahag, a 1935 case, a person intending to rob a store made an opening on the wall of the store, sufficient for his body to enter. His intention was to rob. Before he could enter, he was already apprehended. Can he be liable for attempted robbery? The answer is no, because his OA or overt act of making an opening on the wall of the store is not an overt act directly connected to robbery. It is only an overt act directly connected to trespass to dwelling. Hence, he can only be held liable for attempted trespassing or attempted trespass to dwelling. Although, okay, we can assume that his intention was to commit the crime of robbery. But once inside, okay, inside the store, he may what? He may rob, he may rape, he may kill. So indeterminate pa ang crime na iyang i-commit. Okay? So, or he may injure the owner of the store. Therefore, it is not an act directly connected to robbery. So therefore, attempted lang trespass. Kay ang pag-make of opening is an overt act of the crime of trespass to dwelling. So always remember that. Lain po ng overt act sa pag-commit og robbery, lain po ng overt act sa pagpatay, lain po ng overt act sa pag-rape. Okay? So example, X and Y were fighting. In the course of the fight, X pulled out again. Upon seeing this, Y ran away from X. With intent to kill X, X aimed the gun towards Y and pulled the trigger. At the last minute, Y evaded the bullet. Kalikay ba dyan? Surti ah. So, is X liable for any crime? Of course, yes. The crime committed was attempted homicide or murder, as the case may be. Even if the victim was not hit, since the act of discharging the firearm was with intent to kill the victim, it was already in the attempted stage. Such act of firing the firearm was already an OA or overt act directly connected to the act of homicide or murder, as the case may be. Okay? So the act of shooting the person is a direct okay, is an overt act directly to the act of killing, the act of homicide or murder. Okay? In the same problem, okay, X aimed the gun towards Y and pulled the trigger. Y was hit in the right shoulder. Y safely got away. Upon medical examination, the doctor said that Y's wound will heal within 5 days. Now, what crimes committed by X against Y? Is it attempted, frustrated, or consummated? Remember, wala namatay. Okay, due to a timely medical intervention. So, X is liable only for attempted homicide or murder, as the case may be. Because the wound sustained, it was not fatal. If fatal or mortal wound ang na-inflict and due to a timely medical intervention of survive of victim, frustrated. But if non-fatal wound ra ang igo, attempted ra. Okay? So it requires another act for the crime to be consummated. No one would die by a non-mortal or non-fatal. Take note. So another example. X and Y are enemies. So in one instance, X saw Y outside his house. Angered, X took his gun out of his house. X took aim at Y and pulled the trigger of the gun. However, the gun did not fire the shot. X pulled the trigger again, yet no bullet came out. Wala nag-jam ha, but no bullet came out. So upon inspection, X found out that the gun was not loaded with bullets. Okay, so what crime did X commit? Is it attempted, frustrated, or consummated? So, X committed or X is liable for an impossible crime. Because had a gun been loaded with bullets, X would have committed the crime of murder. Because the gun had no bullets, it is what? Inherently impossible to commit the crime of murder in any circumstance. But if a bullet but nag-jump, okay, that is what? An accident, some cause, okay, or accident. Therefore, attempted. If nag-jam na gani ang gun, attempted na siya. But if walay unod ang gun, walay bullet, that is an impossible crime. But why? Because it is inherently impossible to commit the crime of murder when the gun is not loaded. Okay? Take note of that. So, formal versus material crimes. So, formal crimes are those which are always consummated by a single act. Kaya nang slander o kanang imsumbag ang sa katao, physical injuries, automatic, consummated. Walay attempted, walay frustrated. Okay? But as for material crimes, na 3 stages. Natagitawag na attempted, frustrated, and consummated. Kaya na attempted murder, frustrated murder, or consummated murder if namatay. Okay? So again, formal crimes consummated by a single act. But if material crimes, na ay 3 stages. Okay? Okay. So, 2 phases in the commission of the crime. So, there are 2 phases. Okay, I might ask this, okay, in your quiz. So, we have the subjective phase and the objective phase. Now, what's the difference between the subjective phase and the objective phase? So, in the subjective phase, it is the portion in the commission of the act wherein the offender commences the commission of the crime after the time that he has still control over his acts. He may or may not proceed in the commission of the crime. He has control over his acts. So subjective phase ng attempted felony. Why? Ang offender na po may control whether to really kill the victim or not. So subjective phase. But if objective phase na gani, the moment the offender loses control over his acts, kanang iyan ang nagdunggaban sa abdomen, iyan ang napusilan, objective phase na. That's either frustrated or consummated. Okay? Again, subjective phase, it is the portion in the commission of the act wherein the offender commences the commission of the crime after the time that he has still control over his acts. Subjective phase, napay control si offender. But in the objective phase, wala na siya control sa yung actions. Either mamatay na gyud si victim, kaya yan ang napuzilan or natigpasan, or mabuhi due to a medical intervention. Okay. So we have here stages in the development of the crime. Examples, no, what are the two stages? So internal acts and external acts. So internal acts, are internal acts punishable? The answer is no. Always remember that mere criminal thoughts will never give rise to a criminal liability. There should be what? An external acts. Dapat na kay buhaton. There should be an overt act. Okay? But if mere criminal thoughts lang, like I want to kill him, I want to rape her, etc., no criminal liability. External act. This refers to preparatory acts and acts of execution. So as a rule, mga preparatory acts are not punishable unless these acts are punished in themselves as independent crimes. On the other hand, acts of execution are punishable and depending on the stages of their execution, whether the same is attempted, frustrated, or contributed. External act meaning nanay gibuhat. Okay? So example, so conspiracy and proposal to commit a crime, like conspiracy and proposal to commit a treason, is a preparatory act. Okay? But it is punishable by law. Why is conspiracy and proposal to commit treason punishable by law? Because under Article 115 of the Revised Penal Code, it punishes the crime of conspiracy and proposal to commit treason. But if it is not provided by law kanang conspiracy and proposal, then the acts are not punished. Always remember, as a general rule, conspiracy and proposal are not punishable. But if there is a law that punishes conspiracy and proposal to commit a certain crime, like conspiracy and proposal to commit treason, already punishable na siya. Take note. And also, okay, kanang unlawful possession of piklaks, okay, is punished as a felony under Article 304 of the RPC. Although it may be a preparatory only to the commission of robbery. Okay, so Article 7. When are light felonies punishable? So they are punishable only when they have been consummated. But that's only the general rule. What's the exception? So the exception are those committed against person or property. So what are examples of light felonies? Natin ito nga slight physical injuries, theft, alteration of boundary or of boundary marks, kung nag-irugag mohon, malicious mischief, that's willful destruction of a personal property belonging to another, intriguing against honor, nanglipa ka. Okay? So as a rule, light felonies are punishable when they are in the consummated stage. But, okay, if the crime is committed against person or property, it is punishable even if attempted or frustrated. Okay? Muna yung exception. Crimes against persons and crimes against property. Crimes against person, sa muna, mga murder, homicide, physical injuries, mutilation. Property, mga theft, okay? Alteration of boundaries and landmarks, okay? So why are attempted and frustrated felonies not punishable as a general rule? Because light felonies produce light, insignificant moral and material injuries. If they are not consummated, the wrong done is so slight, gamay ra kayo, that there is no need of providing a penalty at all. And unsa may reason sa exception nga naman pwede attempted, frustrated sa crimes against persons and property? Because the commission of felonies against persons or property presupposes in the offender's moral depravity. Okay? So muna siya yung reason. So Article 8, this is for conspiracy and proposal to commit a felony. So conspiracy and proposal to commit felony are punishable only in cases in which the law specifically provides a penalty. Therefore, as a general rule, conspiracy and proposal are not punishable. They are only punishable if there is a law that punishes it, like conspiracy and proposal to commit the crime of treason. Okay? Wala man tay crime nga conspiracy and proposal to commit murder. Okay? Always remember, nullum crimen nulla pena sine ley. Okay? Ang naara sa balaod is ang conspiracy and proposal to commit treason. Walay conspiracy and proposal to commit murder. Okay? So, what is conspiracy? It exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. So, si A, si B, and si Mr. C, nagsabot nga ilang patyon si D. There is conspiracy. Why? Nagsabot sila, there's an agreement concerning the commission of a felony, the crime of murder, and they decided to kill letter D, Mr. D. Okay? That's conspiracy. However, in proposal, a person decided to commit a felony and then he proposes its execution to some other persons. So, ako, okay, naglagot ko sa katawo. Akong gibayaran si B to kill C. Kaya naglagot ko ni C. So, that's proposal. Why? Because I am decided to kill that person, but I propose the killing to some other persons. Okay, that's proposal. So, conspiracy as a crime. So, if conspiracy or proposal to commit a crime are provided in penalties by law, it is not necessary that there be an overt act committed. The mere act of conspiring, automatic the mere act of conspiring or proposing will already give rise to a crime, provided nga punishable siya under the law. So, the following are conspiracies as a crime under the revised penal code. Natakita nga conspiracy to commit treason, to commit rebellion, sedition, and terrorism under special penal laws. Okay? So, mura na siya mga conspiracies and proposals punishable by law. So, if ever mag-conspire ka, there is meeting of minds, there's an agreement, and then you decide to commit a felony, okay? You are already what? Committing a crime, because the mere act of conspiring and proposing will already give rise to a crime. And take note, it is not necessary that there be overt acts. Overt acts meaning an act that is directly connected to the offense being committed. They are punishable by themselves. Okay? So A, B, C, D, and E come to an agreement to take up arms and overthrow the government and steer public uprising. They already bought guns and pieces of equipment. However, before they could execute their plan, nadaktan sila. So, are they criminally liable? The answer is yes. They were liable for the crime of conspiracy to commit rebellion. Even though they were not able to execute their plan, conspiring to overthrow the government is already a felony, which makes them criminally liable. Okay, that's a good example. And Article 9, so what are grave felonies, less grave felonies, and light felonies? So grave felonies are those which the law attaches the capital punishment, death, or penalties which in any of their periods are afflictive, like reclusion perpetua, reclusion temporal, and prison major. Okay, that is in accordance with Article 25 of the Revised Penal Code. And for less grave felonies, felonies are those which the law punishes with penalties which in their maximum periods are correctional. So kato na yung mga prison, correctional, and arresto mayor. And for light felonies, kato na yung mga arresto minor or fine not exceeding 40,000 pesos or both. Okay? So there are three kinds of felonies according to severity: grave, less grave, and light felonies. So please take note. Okay? So last article, offenses not subject to the provisions of this code. So offenses which are or in the future may be punishable under special laws. What are examples of special laws again? RA 9262, RA 9165. Okay? Are not subject to the provisions of the revised penal code. So the revised penal code shall be supplementary lang to such laws, unless the latter should specifically provide the contrary. So for special penal laws, okay, always remember that the length of imprisonment is fixed. Wala tayo gitawag nga arresto minor, arresto major, prison correctional, prison major, reclusion temporal, or reclusion perpetua. Again, ang length of imprisonment for special penal laws kay fixed. Isulti dito nga, you will be imprisoned for 10 years, for 9 years, for 6 years, etc. And the highest length of imprisonment for special penal laws is life imprisonment. Now, again, what's the difference between reclusion perpetua and life imprisonment? So the difference is that in reclusion perpetua, it is a penalty provided under the revised penal code, and it has a duration that is 20 years and 1 day to 40 years, while life imprisonment is a penalty provided under special penal laws, and it has no length of time. Okay, it is forever. Okay, and also note that the capital punishment of death is now proscribed. It is prohibited. Take note of that. And number two, offenses which are attempted or frustrated are not punishable unless otherwise stated. Always consummated pag special penal laws. And if you will plead guilty for committing use of drugs or possession of drugs, it will not mitigate your liability. Why? Because plea of guilty is not mitigating for offenses punishable by special laws. Okay? And of course, ang mga penalties sa special laws wala tay gitawag nga minimum, medium, and maximum. Kanang minimum, medium, maximum sa revised penal code na siya. Okay? But pwede na ay minimum, medium, and maximum periods for the penalties sa special penal laws provided i-state dito. But if it's not stated, then wala. And there is no penalty for an accessory or accomplice. Okay? Always principal ka if you will violate special penal laws. Walay gitawag nga accessory, walay gitawag nga accomplice. Okay? So that would be all. Thank you. Please stay tuned. Next meeting. God bless.